And okay, little mix up there. All right, so we're going to talk about Chapter 5, Edwards, Civil Rights, and we're going to look at concepts of equality, and equality wasn't really in the Constitution until the 14th Amendment was passed, and there they talked about the equal protection of the laws, or the equal protection clause, which is very important to any of the civil rights movements. If you look at concepts of equality, there is still discrimination in our country, and some of that is reasonable discrimination, which is, according to the courts, is easy to meet. Age discrimination is reasonable. Okay, you're not allowed to vote until 18. You're not allowed to drive until you turn 16. You're not allowed to drink until you turn 21. Okay, it's reasonable to meet those goals. Another type of strict scrutiny is definitely race and ethnicity. The courts really presume that any laws that discriminate are invalid, and uphold them only if they have a compelling public interest. But they look at race and discrimination, and really those laws probably wouldn't serve a minority group, to disadvantage a minority group, that it would serve a compelling public interest. So laws like that are inherently suspect. They receive strict scrutiny. Some intermediate scrutiny would be more gender-based classifications, much like the military draft, and only men are in the military draft. Okay, so those are some concepts of equality and basis of classification that the Supreme Court and courts look at when there is discrimination cases. So let's move on to the African American Civil Rights Amendment. Let's look at some court struggles. Okay, first in Dred Scott versus Sanford in 1857. The Supreme Court ruled that a black man, either free or slave, was chattel or property and had no rights under a white man's government, and that Congress had no power to ban slavery in the Western Territories, which Dred Scott had gone to with his slave owner, and came back saying that since he went to a free territory, he was free. That case went to the Supreme Court, and the Supreme Court ruled as such. We'll also look at Plessy versus Ferguson in 1896. The Supreme Court pretty much said in this case that equal but separate accommodations were fine in cases mostly in the South. So that was for railroad transportation, but the South had that in schools, that they had to be separate black schools, separate white schools, as long as they were equal. We all know that a lot of those schools, black schools, weren't equal to the white schools. They didn't have the better teachers. They had, not a lot of, they had a lot of problems. The heat didn't work, cooling didn't work. They didn't have supplies, stuff like that. So that was Plessy versus Ferguson. Finally, it took a turn in 1954, and the civil rights movement actually was using, education and children, because it kind of tugged at the heartstrings of every American, children and education. And they used this Brown versus Board of Education in 1954, and the Supreme Court basically overturned Plessy versus Ferguson, and said that school segregation was inherently unconstitutional, that separate but equal was unconstitutional or anything but equal. So those were the Supreme Court actions that brought about civil rights and stuff. Some congressional actions that brought about civil rights, some laws. The Civil Rights Act in 1964 ended public discrimination, racial discrimination, sorry, in public accommodations. Okay, kind of like hotel, motel, Holiday Inn. Also, restaurants, train stations, stuff like that. It also forbid employment discrimination on the basis of any race, color, national origin, religion, or gender. So it was a very specific act. Also created the Equal Employment Opportunity Commission to enforce and monitor against job discrimination, and it gave the federal government the ability to withhold grants from state and local governments that practiced racial discrimination. Okay, the other congressional action is the Voting Rights Act, which was very significant, and that happened in 1965. Okay, and of course the states, tried to get around the law of letting African Americans vote, or some states, I can't say all states. And they use specific things, poll taxes, white primaries. And finally, in 1964, the 24th Amendment came about and prohibited poll taxes in federal elections. And then a couple years later, voided poll taxes in state elections through Harper versus Virginia State Board of Elections. But in the Voting Rights Act of 1965, it prohibited any government from using any voting procedures that denied a person the right to vote based on race or color. And so pretty much it banned literacy tests, or constitution tests, they call them. Also, the Voting Rights Act brought in the federal government, to help black voters register, or any voters register, mostly in the southern states that practice these discriminatory laws. Okay, and it ended racial gerrymandering, which meant that Congress draws districts for especially like city councils, and they would draw those districts to disperse the minority groups so they wouldn't get their people that they wanted in local government. Also in state governments too, or congressional districts. Okay, that's about it for the first part of civil rights. We'll also look at, in the next one, we'll look at some minority groups. We'll look at women and gay and lesbians, and then we'll also look at a little bit at affirmative action. Okay.